We're recording.
Morning, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this morning with Judge Prescott and Judge Levine on the matter of CRUZ versus the Commissioner of Correction. AC docket number is 43961. This matter is being conducted over the Teams platform, which means everyone is appearing by video conference. It is also being streamed live on the branch's YouTube channel. I would remind everyone that to the extent there's any protected information in this case, to be careful about not revealing such protected information. I'm going to ask everyone to introduce themselves just so that we can make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Prescott.
I'm Judge Levine.
I'm Attorney Deborah Stevenson.
Attorney Erica Brookman.
I can hear and see everyone okay. I assume that's the same for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. And if you get disconnected from the argument for whatever reason, please go back to the link and log on again. We will suspend the argument until we make sure we have everyone present. I'm going to ask everyone to keep their microphones muted during the course of the argument unless you are speaking to avoid any background noises and avoid people talking over each other. The judges will do the same. We will raise our hands if we have questions and ask counsel to recognize us. If you don't, then we'll just jump in like we would in the courtroom. But again, we're trying to avoid the background noise and talking over. I would remind everyone that this is a court proceeding, and I would expect the same behavior from everybody as if we were sitting together in the courtroom at 75 Elm Street here in Hartford. I would ask everyone to keep their cameras on at all times so we can make sure we can see everyone and everybody's appropriately engaged in the argument throughout. I'm going to keep the time. Everybody, both sides will have 20 minutes to argue. The appellant can reserve some time for rebuttal. Because we do not have our light system in this virtual courtroom, I will hold up signs at 2 minutes, at 1 minute, and when your time is up. So with that, I believe we are ready to proceed. Attorney Stevenson, are you ready to go?
I am, Your Honor. Good morning. I would like to reserve 5 minutes for rebuttal for my client, CRUZ. In this case, the habeas court abused its discretion, in our opinion, in finding the deficient performance of Attorney Gervais did not cause prejudice, and in finding that Attorney Popkins' performance was neither deficient nor prejudicial. The reason we do is varied and many. The habeas court abused its discretion in applying the correct standard, but this was about Attorney Gervais, and in this section, an Attorney Gervais coerced the petitioner into pleading guilty. Gervais failed to mention the charge was murder and not manslaughter. He told my client that he had to plead guilty and not just to answer yes to answer yes to the judge's questions. In other words, he gave him no choice. He had to answer yes. He had to plead guilty. No uncertain terms. This was admitted at the habeas trial. I apologize for that, Your Honor. Hold on 1 second. So this was quite blatant and obvious that Attorney Gervais acted deficiently. He only had the case for a short amount of time. He didn't see him really at the jail facility where he was incarcerated. You saw him for a few minutes each time at the trial court appearances in the lockup in the courtroom, and basically coerced him into pleading guilty. Now that was Gervais's performance. The trial court, the habeas trial court, assumed that was deficient. But he found no prejudice in that. And the reason he found no prejudice was not because of what Gervais did. The habeas court found no prejudice because my client, eventually pleaded guilty with an alternate counsel, and the evidence against the petitioner was overwhelming, and it's clear the prosecutor was never going to change the charge to manslaughter from murder. Now, neglected to mention that when my client went in the courtroom to plead guilty with Gervais, Gervais had not told him that he was pleading to murder. He wanted to plead to manslaughter. So this was a surprise to my client when he was pleading guilty to begin with. So, but the point is that the standard is really not whether the petitioner pled guilty or whether the case was overwhelming or what the outcome of the trial would be. whether the prosecutor would agree to a manslaughter charge. The standard is whether, but for counsel, Gerace's performance, would my client have gone to trial? And there's sufficient evidence to show that he would have gone to trial and not pleaded guilty. The evidence, he was very adamant about that not pleading guilty to murder. He was remorseful and wanted to plead to manslaughter, because he believed he had no specific intent to commit the crime of murder. And this was reasonable under the circumstances. He had never committed a crime before. This was the first crime he committed. He had no specific intent to commit murder. Now, there was some history of abuse and possible mental health issues that would have been relevant to show specific intent for murder or not, if had he gone to trial. So in his opinion, this was why he wanted to go to trial, to show, I didn't intend to do this. Something happened that day. Yes, the victim was killed and I had a responsibility for that, but I did not commit murder. I had no specific intent to do that. And he wanted to plead to manslaughter to atone for that which he recognized, but it was the issue of manslaughter versus murder and his specific intent that was in his mind. And so there was sufficient evidence to show that but for Gerace coercing him into pleading guilty on a charge he wasn't even aware of before he got into the courtroom before the judge, and where he was told to just say yes, had never even been in the courtroom before on any other charge. There's sufficient evidence there to show that that was prejudicial, and it was Gerace's deficient performance that caused that prejudice. This is not really an objective assessment of a rational decision that the trial court should have made. This should have been based on more of a subjective assessment of what the petitioner would have done. That is the Hill standard, and that's what the court should have done, but did not do. And that's why, with regard to Gerace, I believe the court was wrong. Now, with regard to Attorney Popkin, the alternate counsel, who came in after my client filed his motion to withdraw for the purpose of helping him with the motion to withdraw, again, there was deficient performance, ineffective assistance, and prejudice with Attorney Popkin. Now, Popkin's duty at that point was to investigate, and let's go forget the motion to withdraw for a minute. With regard to his duty at sentencing, because obviously Attorney Popkin talked my client into pleading guilty as well, because he. Yes, Your Honor.
Attorney Stevenson, when you say let's forget the motion to withdraw for a second, I don't see any issue briefed regarding the motion to withdraw. It appears that all you've briefed is the sentencing issue regarding Popkin.
Right. That's true. Okay. That's true.
All right.
But that is relevant only because the court used that argument that he pleaded guilty, and Attorney Popkin, convinced him to withdraw the motion to withdraw. But with regard to Attorney Popkin in sentencing, the trial court did overlook counsel's duty to investigate and present all mitigating evidence. The habeas trial court did not consider or apply Patterson, for example, or Dennis or Carter. Under Patterson, our Connecticut Supreme Court case, it's stated right in there that effective counsel will present to the court all relevant mitigating material consistent with the defendant's best interest, and the counsel must seek to verify information in the PSI and be prepared to supplement or challenge it if necessary. Under Dennis, counsel has a duty to make a reasonable investigation before sentencing, or make a reasonable decision that makes investigation unnecessary. And what happened here? What did Popkin say? He said, well, why didn't he investigate? Why didn't he, challenge the PSI or do all this? Why? Popkin himself said he didn't because it didn't seem necessary and because it would have been a waste of time. In other words, Popkin made a subjective decision on his part alone. Why should I bother investigating? Why should I bother, doing anything more here? It'd be a waste of time. And that goes also to why he convinced the client to withdraw the motion to withdraw. But under Carter, which is a United States Supreme Court decision, the need for effective counsel at sentencing is greater than the need for effective counsel at trial, because the court exercises wide discretion in the imposition of penalty. So the habeas court failed to apply those precedents in determining the deficient performance of Popkin. Now, with regard to the prejudice of Popkin after that deficient performance, the court, again, while the court articulated a correct standard in the beginning, in this particular instance, with regard to the prejudice of Popkin, the court used the Strickland standard rather than the Hill standard to determine the prejudice. The court used...
Attorney Stevenson, why
Yes?
would Hill apply here when the issue for Popkin wasn't whether he would have gone to trial, but whether the failure to present the mitigating evidence would have resulted in a likely change in the outcome, which is the Strickland standard?
Well, because I think we're talking about him pleading guilty at sentencing and not after a trial. And I think that the cases with regard to Strickland have to do all with whether after a trial. So I think it is relevant because that is what is applied when you're pleading guilty. And now, granted, sentencing is sentencing in both cases, but there is a distinction for when you are sentencing because you have chosen not to go to trial. And I definitely think that is a relevant consideration in this case in a habeas matter as to whether counsel provided prejudicial deficient performance, because presumably under Strickland, counsel would be the same counsel in most cases. Counsel would have gone through the whole trial procedure, presented evidence, done everything, and presumably counsel would have known all of those factors in arguing for sentencing. Here we have an alternate counsel to begin with and no trial. So that counsel had more of a duty to investigate and present the mitigating evidence for sentencing. And so I think that the Hill standard does apply whether he would have gone to trial. But aside from that, Popkin did not perform the way he should have. His performance was deficient, and in that it was a complete breakdown in the adversarial process during sentencing, because his job was to persuade, to present the evidence he should have investigated, and to argue all the mitigating evidence for the lowest possible range. Instead, he agreed with the prosecutor's presentation of the facts in the PSI, and pretty much everything that the prosecutor said at sentencing. Popkin actually harmed the petitioner's argument. He acknowledged the petitioner got a hold of the gun and shot it. Fine, so did the petitioner. But Popkin stood there at sentencing and repeated 4 times that the petitioner shot it, shot it, shot it, shot it. Okay, he showed Popkin's agreement with the prosecutor at sentencing. In fact, he ended his initial argument, such as it was, without mentioning any of the years that he was requesting. He ended it. The court had to then come back and ask him, well, what are you recommending then that I sentence this person on? How many years? And at that point, he told the court, actually, the minimum of 25 is not appropriate. So my client had an agreement for a minimum of 25 and a maximum of 42. And what does Popkin do? No, Your Honor, the 25 years is not appropriate. I agree with the prosecutor. That's not appropriate. So that's worse than what happened in Davis. In Davis, yes, Your Honor. I can't hear you, Your Honor.
Why wasn't Attorney Popkin's decision basically a strategic or tactical decision? It's not uncommon for a lawyer to fail to ask for the best possible legal result because he thinks that will not be persuasive or realistic, and therefore might actually hurt the client. Why can't we just simply conclude that that's why Popkin did what he did?
Well, because I think we have the standards that I mentioned before, that he's supposed to be advocating for all the mitigating evidence available, and he had available to him a lower minimum of 25, and not to mention the fact that he didn't even mention to the client that he was going to agree with the prosecutor 25 is not appropriate and I'll go for something different.
And your argument is that the defense lawyer must always ask for the lowest available sentence or they're not effective, correct?
No, that's not what I'm saying, Your Honor. There might be circumstances where that might be appropriate, but I don't see the facts here as being appropriate because, again, the deficient performance here is Popkin never even mentioning any of this to his counsel, to his client, and the client never even agreeing to that. I see I'm running out of time, so let me go forward to say that this, again, is worse than I think than in Davis, because in Davis, that counsel was pretty much silent, whereas this counsel, you do have evidence that although he was making a little bit more argument, the argument was in favor of the prosecutor, and he didn't even have his client's agreement or even understanding as to what he was going to do. And he just threw out a number. He just threw out a number of 32 years. He didn't even not know rational reason for it or anything. Well, I just think because it was his subjective opinion, it was clear that it was not based on something else factual, reasonable. It was simply, it's a waste of time for me to do anything else. This is what I think. Here's 32 years. And with that, I will reserve my 5 minutes.
Okay, you have a minute left, so you'll have 6 minutes for rebuttal.
Thank you, Your Honor.
Attorney Brookman, you ready to go?
Yes, Your Honor. Thank you. Good morning, Your Honors. My name is Erica Brookman, and I'm representing the Commissioner of Correction in this matter. I do have a few points to make. I would ask that this court affirm the judgment of the habeas court as it properly determined in this case under the standards of Strickland versus Washington and Hill versus Lockhart, that the petitioner failed to demonstrate that he received the ineffective assistance of counsel. The first issue is whether the habeas court in this matter properly determined that Attorney Gerace did not render ineffective assistance of counsel. And in doing so, the habeas court applied the Hill standard and determined this case on the prejudice prong alone. There was no analysis, as petitioner's counsel suggests, as to deficient performance in this case. There were limited factual findings in that regard, and the court engaged in no analysis of the deficient performance prong. And in this case, with respect to the prejudice prong, the habeas court had to determine whether there was a reasonable probability that, in light of all of the circumstances, the petitioner would have insisted on going to trial. And in this case, the court decided on a number of factors that his assertion that he would have done so was simply not credible. And the factors that the court discussed in its opinion was that there was overwhelming evidence in this case, suggesting that the petitioner was the individual who committed this crime. There was a video surveillance recording that showed the petitioner running into the scene, and the state, in fact, testified at the habeas trial that that was a very important piece of evidence for the state because it showed that this was, in fact, an intentional crime. He intended to murder the victim in this case. There was also a number of witnesses who were going to testify that they saw the defendant shoot the victim in this matter. There was DNA evidence where the petitioner's DNA was found on the handle of the firearm. And there was also some ballistics report that also was suggestive of the firearm that his DNA was found on was used in the commission of this murder. So the habeas court considered that evidence, as well as the fact that there was no presentation of a viable defense. In fact, Attorney Popkin, who subsequently represented the petitioner in this matter, testified he reviewed this case and he had these discussions with the petitioner, and that there was simply no viable defense, that he thought the strategy here would be best to pursue his plea and go to sentencing because he was not going to prevail at trial. So this is evidence that the habeas court considered in determining whether his insistence that he would go to trial now was credible. And the habeas court simply found it was not. There was no evidence to support his assertion, and therefore the habeas court properly determined that there was no prejudice to the petitioner With respect to the second issue, and that is whether the habeas court properly determined that Attorney Popkin did not render ineffective assistance of counsel in this matter. And there are 3 points with respect to that issue. The first being the habeas court applied Strickland versus Washington, and in doing so determined that there was no deficient performance on the part of Attorney Popkin with respect to his strategic choice in representing the petitioner for the sentencing phase of these proceedings. In this case, again, Attorney Popkin reviewed the entire case and discussed that with the petitioner. He also reviewed the pre-sentence investigation with the petitioner and made a strategic choice to seek to mitigate the sentence. And in fact, the habeas court found that Attorney Popkin not only presented mitigation argument in this case, but asked for a lower sentence. And in doing so, Attorney Popkin had discussed with his client the overwhelming evidence in the case and had made a decision to utilize the information contained with the pre-sentence investigation report to emphasize the positive attributes in the petitioner's life, such as the fact that he didn't have any prior criminal involvement with the criminal justice system. He had a positive employment record. He also sought to bring out to the court the fact that he had himself had some traumatic events in his life, that he had been subjected to domestic violence in his household, that he grew up in a very poor household and had some struggles in that regard. But more importantly was that Attorney Popkin in this case repeatedly discussed the petitioner's remorse in this matter, and in fact testified at the habeas proceeding that the transcript of his expression of remorse simply doesn't do it any justice, that when you were there and present, it was a really heartfelt expression and focused on that he was remorseful. So in this case, there were no mental health issues brought to the attention of Attorney Popkin, and he testified that he didn't believe that there were any mental health issues, and for that reason didn't pursue that avenue any further. And indeed, the strategy in this case to emphasize those positive attributes and his remorse, ultimately in this case, the trial court did in fact depart from the maximum potential sentence that it could impose, which takes me to the prejudice analysis in this case. And first and foremost is the habeas court in this matter applied Strickland versus Washington rather than Davis versus Commissioner of Correction, because the habeas court in this matter found that there was mitigation presented and there was a request for a lower sentence. So counsel in this matter, unlike the petitioner in Davis, did in fact do something, and he didn't just follow the recommendations of the pre-sentence investigation report. In fact, there was no sentencing recommendation in that case, unlike Davis, where there was a sentencing recommendation. He didn't acquiesce to what the state was asking for in this case. The state was asking for 42 years, the maximum that the court could impose. And habeas counsel in this matter testified that his rationale in not seeking the lowest possible sentence was he wanted to maintain that credibility with the court. And he wanted the court to duly consider his suggestion that it depart from the his knowledge that the trial court was looking at something in the high 30s. And so he suggested 32 years, which was significantly different from the recommendation of the state's attorneys. And so the court in this matter found that as a result of that, there simply was not a case here for the presumption of prejudice, and properly went forward an analysis under Strickland versus Washington's performance prong. And again, in doing so, the habeas court in this matter found that petitioner's counsel did present mitigation evidence, requested a lower sentence, and in fact, the trial court did depart from that maximum sentence that it could impose and imposed a 38-year term of imprisonment. And most of the information adduced during the habeas trial, the habeas court determined was provided to the trial court, with the exception of one limited area where the court was not aware that at one point in the petitioner's youth, he was shot in the leg. So, but outside of that, the court determined that that would not have changed the outcome in this case, and properly determined that Attorney Popkin did not render ineffective assistance of counsel. Unless there are any questions by this court related to any of the points that I've made or contained within the brief.
I see no questions from the panel, so thank you very much.
Yes, Your Honor. The state would then just ask that this court affirm the judgment of the habeas court. Thank you very much.
Okay. Attorney Stevenson, you have 6 minutes.
Thank you, Your Honor. Yes, with regard to the assertion that it was not credible, with regard to Gerace, okay, it's not credible that, you know, that this was prejudicial or that he would have gone to trial. The problem with the habeas court's determination is that, again, we go back to the standard, and the standard is what the client would have done. Would he have gone to trial or not? Now, the credibility of the client in doing that is not, it's not relevant what Attorney Popkin did later, and it's not relevant, you know, those are, they're, first of all, it's not relevant at all with regard to Gerace, what Popkin did later. We're talking about Gerace's deficient performance and how that affected the client. Again, this is a client who had no prior criminal history, no experience with the court, no experience with pleading guilty, is told he has to do this and he has to say yes to everything the court ordered. Now, under those circumstances, would he have gone to trial or not when he believes on a murder charge, which he wasn't even told about till he gets in front of the court? Is it credible at that point that he would he have gone to trial had he known all those things, had he had the opportunity to discuss everything with Gerace at that moment? And everything that happens later stems from Gerace's deficient performance. So I don't believe that that's a valid reason to determine, as the court did. With regard to Attorney Popkin, well, counsel says that Attorney Popkin presented sufficient mitigating evidence and asked for a lower sentence. Well, that's not exactly accurate, because Attorney Popkin did not investigate at all to find any mitigating evidence or to determine who to present in terms of how to mitigate any possible sentence. He did have a notice that there was possible mental health defenses here because of the PSI. PSI, he had it in front of him, and basically all he did was reiterate what was in the PSI. He didn't go looking for anything. He just stated to the court what the court already had in front of it. That's not mitigating evidence. That's, the court already had that. His job was to verify what's in the PSI and find if there's anything mitigating about it. And when it's in the PSI that he had an abusive, you know, childhood and all of these things happened to him, yet he didn't commit any other crime before now, that's in and of itself enough for any counsel to go and investigate. Well, why did he do this now? There must be, even the court was confused about why he did that now. And obviously there is a possible defense of diminished capacity or a mental health issue of some kind, yet he didn't even ask a mental health expert, well, what do you think about this? Is there a possibility? So did he present mitigating evidence? I don't think so. He didn't really at all, not under the standard under Davis, certainly, and not under the other cases that I mentioned previously. He had that duty to investigate and present that kind of mitigating evidence. As far as he offered a recommended sentence, no, he didn't. He would have closed his case completely without any recommendation at all had the court not asked him, well, what are you recommending? So again, why didn't he do that? Because he figured it wasn't worth it. This was, already something he agreed with the prosecutor. So that's not subjecting the prosecutor's case to an adversarial testing. It is simply not, and that warrants a presumption of prejudice under Davis. He had a duty to investigate, to present the evidence, to advocate fully for the sentencing that was agreed upon, 25 years to 42. It was an afterthought to throw out 32 years. He wasn't even going to do that. So unless there is any other question, I see I'm running out of time. I rest on my brief and ask the court to reverse the decision of the habeas court.
All right, I see no further questions, so thank you very much. Appreciate your working with us today in this virtual courtroom. We hope to see everyone back in our physical courtroom very soon. We will take the matter under advisement, and the court will stand in recess until 11:30 this morning. Have a good day.
Thank you, Your Honors.